Welcome, everyone. Again, this is Kara Maciel and Andrew Sommer from Maciel Carey, and today we're conducting another of our series of webinars from the Labor and Employment Practice Group here that we've done throughout the year. And today we're talking about a really important and frequently questioned issue regarding navigating the intersection between the FMLA, the ADA, and workers' compensation. This session is being recorded, so it will be made available to all participants after the webinar, and Andrew and I will also circulate copies of the slides. So if you want to keep copies for later or circulate them to anyone who was unable to attend today, please feel free to do so. We also have a Q&A function on our webinar platform, so if throughout the presentation you want to ask Andrew or me a question, please type your question there and we'll either try and answer it when it comes in, but hopefully we'll also have some time at the end of the webinar for some questions. And with that, we'll just sort of jump right in. For those of you who don't know me or haven't participated in one of our webinars before, I am the founding partner of Maciel Carey, and I lead our national labor and employment practice. I do everything in the A to Z of the employment relationship, from advising employers on hiring, interviewing, onboarding, to getting people working in a productive and happy way in their workplace, all the way through to the end of the employment relationship. If there's an issue that comes to litigation, I regularly defend employers at the state and administrative levels on claims of discrimination, and also in federal court as well, particularly as it relates to these issues that we're talking about today, the ADA and the FMLA. I'll let my partner, Andrew Sommer, introduce himself before we get into the bulk of the presentation.
I am Andrew Sommer. I am a partner heading up the California practice for Maciel Carey. My practice involves both defending litigation in state and federal court involving a myriad of different employment-related issues. And I also counsel employers on various employment-related issues. And as Karen mentioned, an issue that frequently comes up, particularly in California, involves issues of leaves of absence and reasonable accommodations and the various matrix of legal compliance considerations. I also conduct trainings on employment-related issues. And lastly, this issue of FMLA, ADA, workers' comp, this comes up so often, and I'm very much looking forward to presenting with Kara on this subject.
Thanks, Andrew. So yeah, I mean, as the year started and we were putting together our materials and what we wanted to present on over the course of the year, this topic absolutely came to mind immediately. Oftentimes when I'm presenting and I get feedback about topics that people want to hear about in the future, this is one of them. And in fact, I was having lunch with a colleague a few months ago, and one of the things he mentioned was the importance of thinking about workers' compensation anytime someone requests a leave of absence, because I think oftentimes HR tends to go right to ADA or maybe to FMLA, but do you ask the very first question, well, is this leave work-related? Is it related to a work-related injury and therefore triggers the workers' comp claim? So in thinking about this, one of the most important messages that Andrew and I want to send is think when you've got any type of leave of absence, you definitely want to think about whether the leave relates to the injury, and then what do you do next? It's definitely going to come into the three main areas of the law. You've got the Americans with Disabilities Act, you've got the Family and Medical Leave Act, and you've got the applicable state workers' compensation law. And so what we're going to talk about today is the common issues in navigating among these three laws in order to come to a good resolution for your employee's request. The ADA, very briefly, that protects discrimination based on someone's disability. And we're going to talk about what a disability is under the law. And if someone is disabled, then you need to be able to provide a reasonable accommodation for that individual with a disability. Importantly, it's not always the accommodation that the employee so chooses. So long as the employer chooses a reasonable accommodation, you can choose your own selected accommodation under the law. The second key law is the Family Medical Leave Act. This law requires employers to provide up to 12 weeks of unpaid leave when that individual has a serious health condition or they have a birth or adoption of a child. Importantly, this leave is unpaid, although many states and local jurisdictions have some equivalent law that may provide for paid leave, and we are certainly starting to see that become an issue across the jurisdictions, and even Congress is thinking of introducing a paid leave law. I'm not sure how far that will go, but for right now at the federal level, we're just still talking about unpaid leave. And then the third triangle statute you want to think about is workers' comp. This is not a federal law, but it is regulated and mandated by federal law. It requires and is implemented by state workers' comp insurance, and that provides compensation to an employee who is injured in the workplace. And it's important because it really limits your liability for some type of torts that may come up in the workplace. When Andrew and I are frequently litigating cases like this, and we've got an FMLA claim or an ADA claim, sometimes we'll see an intentional infliction of emotional distress claim pop in, or some other tort claim, a negligence claim. Those claims are preempted if they occurred in the workplace. Those are preempted by the state workers' comp statute. So understanding your limit to liability under those claims are going to be very important. But the very first thing you want to do when a question hits your desk saying an employee is requesting leave for a particular reason, you need to find out which law applies. And the applicability of each law really depends on the size of the employer and the basis of the leave request. So specifically, you've got the ADA and the FMLA. Those only apply if the employer has a minimum number of employees. So you've got 15 employees for the ADA and 50 employees for the FMLA. If you fall under those thresholds, again, look to your state and local jurisdictions because you may have equivalent state laws. But for the federal laws, they have listed those 15 and 50 employee thresholds appropriately. Workers' comp laws, though, also vary by state, but usually do apply even to the most small employers. Whether you've got 1, 2, 3 employees, you likely will have to have some type of workers' comp law, statute that will cover you. And unlike the other two laws that I talked about, workers' compensation is only relevant if the injury arises out or in the course of employment. So if you've got a facility with lots of different locations, or you've got individuals that are driving from one facility to another and they get in a car accident, you need to find out quickly whether that accident and injury occurred within the scope of their employment or somehow occurred outside of their regular course of duties. The ADA is relevant when a request for leave is made only if the employee's condition constitutes a disability as defined by the law. We're going to talk about that specifically if it limits one or more major life activities and the employee can perform the essential functions of his or her job with or without a reasonable accommodation. The FMLA, on the other hand, kicks in if the employee or the employee's immediate family member has a serious health condition. And a serious health condition is defined much more broadly than a disability. So you want to think about maybe sometimes the ADA and the FMLA may apply together, or just the FMLA may apply if the serious health condition does not rise to a disability. So as I mentioned, we talked about state workers' comp laws. Most employees have to carry them, and you've got to really look to your specific state law to understand what your obligations are and what the employee's rights are. Under the ADA, you want to think about what is a disability. As I mentioned, it's broader and it's defined by law. Several years ago, the ADA was amended, and that really expanded the definition of disability. But what it is, it's a physical or mental impairment that limits a major life activity. And the way that Congress expanded major life activity includes things like thinking, concentrating, working, walking, things of that nature. So almost anything at this point is going to be a major life activity that could be impaired. It also could include perceived impairment. So if someone is perceived to be impaired based on how they're acting, if the employer perceives them to be disabled, that's also covered. But what is not covered is temporary medical conditions. And so the questions that Andrew and I get a lot are, well, is pregnancy a disability? And the answer to that is no, because pregnancy is a temporary medical condition. But to the extent that there are medical complications associated with a pregnancy, whether it's preeclampsia, maybe it's an issue where someone needs to put on bed rest, maybe the child has some issues, that then could translate what is otherwise a routine pregnancy into a medical condition where they may be covered as a disability prior to giving birth. As I mentioned earlier, disabled employees are not always eligible for FMLA leave, even because, for example, you might not have the right size of employer, or maybe the employee hasn't worked for the company for a year, which is required for FMLA coverage. So you want to think about that you might have an ADA issue where you might not have an FMLA and how those two interact. A question I get when I talk about the ADA in particular is attendance. And is attendance an essential function of someone's job? And the answer is yes. You can generally treat regular attendance as an essential job requirement, and you do not need to accommodate erratic or unreliable attendance. Usually, if someone who has a disability prevents her or him from coming to work on a regular basis, fails to meet that essential function test, and does not fall under the ADA. So communication there is key. You want to find out why they might not be coming to work, but importantly, if you've got erratic attendance, unreliable, someone's late all the time, it might be an FMLA intermittent leave issue if it's a migraine or if there's some medical serious health condition, but generally it will not be considered a disability for purposes of the ADA because coming to work on a regular basis is considered essential function. On the other hand, the question then arises about telecommuting, and we're starting to see that more and more courts and the EEOC look to telecommuting as a possible reasonable accommodation under the ADA, except where regular attendance is an essential job function. And so this question comes up, well, what about, I need someone in the office 5 days a week, 9 to 5, I cannot have them perform their job. Well, is that true? You really want to look at the job descriptions. You really want to do what they're doing as in their actual duties to see if it's something that can be done from home. The ADA does require an option of potential job restructuring or telecommuting if it's a reasonable accommodation. But then you get into a lot of issues of how do you manage that person who's telecommuting if you don't otherwise have a remote workforce. But in today's day and environment with technology, with people's ability to dial in pretty much remotely anywhere, there's very few jobs that the EEOC and the courts consider to be required to be on site all the time. And so certainly something when someone comes to you and says, I'm looking for telecommuting as a reasonable accommodation, make sure that's a red flag. Don't automatically deny it. You want to go through your regular ADA accommodation analysis to find out, A, does this person have a disability? Is regular attendance an essential function of their job? And if not, how would telecommuting work for your particular organization and the job functions that that individual does? And if it substantially alters it or creates an undue burden, then that would not necessarily be required. A question just came in since I'm on this slide about what types of accommodations are available as recommended options for employees who already work remotely from home. Well, so there's an interesting issue. If you've got employees who already work remotely, then telecommuting is a reasonable accommodation, no doubt. If they need other types of accommodations, it may be that they might need different types of computer screens. They might not need depending on their disability. You have large computer screens at your offices, but the individual has a laptop at home. So it might be that if you allow them to work from home, you might also need to provide larger screen equipment, depending again on someone's disability. So it really is going to vary based on who's making the request, what is reasonable, but also what is an undue burden. I don't think outfitting every single person who works from home with a stand-up desk may or may not be a reasonable accommodation, but I'm hearing that a lot of people are asking for, the ergonomics of a work site at home just as they are in the workplace. So just different things to consider. FMLA, on the other hand, as I said, has a broad definition to include a serious health condition, which is an illness or an injury, impairment, or a physical condition, really that involves, inpatient care in a hospital setting or inpatient setting, an overnight stay, or you've got, repeated treatment that's connected to inpatient care, or continuing treatment by a healthcare provider. So you want to think about that in terms of, is someone who's going out on leave, is it something because they're going into the hospital? Are they having surgery? Will they be in the hospital for a couple of days? If so, FMLA is likely triggered. Is it a pregnancy, for example? FMLA will be triggered when someone goes into the hospital to deliver birth. They may stay in the hospital for 24, 48 hours. They may be in the hospital for 5 days if they have a C-section. That would be considered an FMLA triggering event, even though pregnancy itself may not be considered a disability. Continuing treatment by a healthcare provider, and this is where a lot of times I hear the issue of migraines come up. All right, so someone has migraines and they need to go see their doctor, every month for a particular, a treatment, or they need to be able to, take time off in certain periods of times if they know they're going to have a migraine during a certain time of the year or month, or seasonal issues, seasonal allergies. Those are the kinds of things that can be very struggling to address with intermittent leave, and Andrew's going to talk about that. But so long as someone is under the continuing treatment of a healthcare provider, that is going to be a triggering event for a serious health condition under the FMLA. But things that are not a triggering event under the FMLA are things that are, routine or temporary, right? So going to the dentist and having cavities filled or a root canal, likely not going to be an FMLA triggering event. If someone has the common cold or gets the flu in the wintertime, upset stomach, those kinds of things that can be treated over a day or 2 days are not going to be considered health conditions. Headaches, as I talked about migraines. Migraines likely will be considered a serious health condition, but just general headaches that can be treated with over-the-counter medicine will not trigger FMLA. Anything also taking over-the-counter medication. If you've got a condition where you can generally take Advil or Tylenol on a regular basis and that seems to suffice, then that's going to not have FMLA coverage. Cosmetic treatments. Unless inpatient care is required, generally is not something that is going to be considered a FMLA issue. A question just popped in that said, if a pregnant employee is placed on restrictions by her doctor that we cannot accommodate, does that qualify as FMLA? It could be. It absolutely could be. If the doctor, if she is under, going back to the previous slide, if she's under regular continuing treatment by a healthcare provider, if you can't accommodate her for one way or another with light duty, for example, or with leave or continuous leave, you can, as a serious health condition, do intermittent leave, or you could put her on, if it's bed rest, you could put her on consistent leave, and that would qualify as FMLA. The challenge there is realize that FMLA leave is only, at least under federal law, is only 12 weeks. So if someone uses FMLA while they are pregnant prior to childbirth delivery, realize that's going to tack into any leave that they may want to use, not for their serious health condition, but maybe for the second reason under FMLA, and that's to care for a newborn baby at home. So that's another way that you really need to understand the intersection of FMLA and the ADA, particularly with pregnant employees, not to get too much past the 12 weeks. So with that, I'm going to turn it over to Andrew to talk about the length of the leave of each of these statutes.
Thank you, Kara. To start off with, I did want to mention that depending on where you operate your business, you'll need to take into account other leave statutes under state law. For example, in California, we have the California Family Rights Act that is largely an equivalent of the FMLA with some significant differences. And then we also have the Fair Employment and Housing Act that has its own standard for reasonable accommodations and disability discrimination that in some ways or many ways is equivalent to the ADA. And so depending on your state, you may have different statutes. Also, some states like California have pregnancy disability leave statutes that you also have to keep in mind. For the purpose of the webinar, we focused on a more generalized audience so we can cover issues that are of common interest, but that will apply the concepts in the various state contexts. But to begin with, addressing the length of leave, the FMLA has a firm 12-week entitlement to unpaid leave. And this leave can be intermittent, or it can be for the all in one period of time. In terms of intermittent, that's referring to whether there's multiple stints. For example, the employee comes or seeks a time off of 2-week duration and then seeks to go back out on leave for another month, and this can occur over a period of time. We'll be discussing how to handle intermittent leave later in the webinar. But it's a firm 12-week period of time, and it's important that this leave be properly designated by an employer so that it's exhausted. You want to get out from under the umbrella of FMLA, which is stricter in many ways than the ADA. But once the employee completes the 12 weeks of FMLA leave, that's not the end of the story. You need to then consider whether to provide additional leave as a reasonable accommodation if it's requested. And that is a very fact-intensive inquiry. And you're essentially looking at whether the employee can return to work in the foreseeable future. And that is vexing for employers because oftentimes you get a doctor's note from the employee indicating that the employee is going to be off for a month. And then as the employee approaches the end of that 1 month, you get another doctor's note for another month. And this can go on for 14 months, for example. And so it's each time you get the doctor's note, it appears that the employee can return soon and that there's a basis for providing additional leave as a reasonable accommodation. And so my recommendation is always, when you're dealing with these difficult leave situations where you have a long leave of absence that's been requested, there is, a cost-benefit analysis in assessing the risk, but ultimately I recommend consulting with employment counsel before terminating employment based on the leave being too long. And the standard, unfortunately, just isn't clear enough. It could be so much clearer, but you're essentially just looking at whether the employee can return in the foreseeable future as a general rule of thumb. And two related considerations as well are whether to hold open the position for the employee and whether to maintain the employment status. So you may be in a situation where you say, well, we can certainly keep this employee on the books as an employee for a period of time that goes beyond the FMLA leave entitlement. But then the question is, do we really need to hold the position open for the full length of the leave? And that there's undue hardship and questions about whether that's a reasonable accommodation that largely depends on the nature of the position and the operational impact. Another consideration here is workers' comp. Workers' comp has no limit on the length of leave. It's based on the nature of the injury, and you're largely going to be working through the workers' comp process in evaluating the nature of the injury and whether there's any work for that individual or whether the person needs to be placed on a leave of absence. Now, addressing the next slide, which is concerns the difference between the ADA and the FMLA. There's some significant differences. So as we discussed, once the FMLA leave is exhausted, that's not the end of the road. You go into this ADA accommodation mode. And what you're essentially doing is you're engaging in what the required interactive process. And the process for FMLA is much more straightforward in a way. You receive the notice from the employee of the need for FMLA leave. You designate that leave. You track it. Typically end of story. And you show that it's been exhausted. And then there's reinstatement issues. But for ADA accommodation, the interactive process is key. And if there's a breakdown in the interactive process and that's attributed to the employer, there can be a finding of liability by a court. And so what's very important is that when just in a nutshell, even outside the leave context, you're looking at, if there's a request for accommodation, you are then exploring what sorts of accommodations are available based on the employee's restrictions. So the framework is typically you're looking at the position that the employee has presently. Can that employee remain in the work in that position despite the restrictions? And so you're looking at whether you can reassign marginal, non-essential job functions. If that can't be done, then you start looking at, are there any open positions outside of the current position for which the employee can perform, or is qualified to perform the job. And then you're also looking at a possible leave of absence. If there is no alternative position and the employee cannot perform his or her current position. So that's the general framework. And what's challenging in the ADA context is that this can be a real fluid process, and you can have an employee that's coming back to you every few weeks with different restrictions requiring different accommodations. So it's pretty easy in this process to drop the ball and to have no follow-up with the employee or no response to the new restrictions. And so it's really important to be tracking this. But moving to the next bullet here, another significant difference between the ADA and the FMLA is the notion of what the covered condition is that provides this entitlement. Under the FMLA, it's a serious health condition, as Kara just discussed. And as she also discussed, the ADA, it's a disability. Typically, disability under the ADA or some of the equivalent state laws is fairly broad. Seems almost anyone can have a disability to a degree. And where a serious health condition is a little bit more rigorous. So typically when an employee does go out on FMLA leave, many courts or agencies just presume that by having a serious health condition that individual is also disabled under the ADA or equivalent state law. And then, as indicated, we must consider further leave under the ADA after the FMLA leave is expired. And also, as mentioned, there is no set timeline for ADA leave as to what is required, and that has been frustrating both for employers and their attorneys in assessing ADA leave claims, because you can have a court that can find that 6 months of leave in a given situation was plenty of leave, and at that point the employer was in its right just to terminate that employee's employment based on that being such a long period of time. And there's been other courts that say, well, you should maybe give a year where it looks like that employee could return. So there's a really significant assessment of risk. There is a reference here to light duty. We're going to get to that in a moment. But you're really looking at the litigation risk and the threat of litigation, concerns that you may have when making these decisions. And so typically I recommend provide the full extent of the FMLA leave if there's an entitlement, reinstate to the same position except for in very extenuating circumstances. And then when you get to the ADA issues, that's when you have a little bit more discretion. You're looking at it case by case. And so, we do have clients where, we look at their operational considerations. We realize there's no way we can hold a position open, for example, for a year while the employee's out on leave. So they make a determination and they say, well, let's hold the position open for a reasonable amount of time. It's a position that where the job duties cannot be performed by a temp or by other employees in the workplace. We might just have to, in a number of months after the FMLA leave expires, just go ahead and fill that position and then make the decision to potentially keep the employee on the books as an employee and then evaluate over time how long to keep that employee employed during that leave. All right, so and then looking at next notice issues. Many employers think that there has to be this formulaic process of providing notice of a need for leave. This slide's addressing FMLA leave. I'll address both ADA and FMLA and how those are different. But typically, an FMLA leave can be verbal, can be in writing, can be almost in any format. And the key here is that the notice has to be sufficient to make the employer aware of the need for a leave of absence that qualifies under the FMLA and has to indicate the duration and timing of leave. So the employee doesn't have to come out and say, I need FMLA leave. Once you have enough information indicating the need, you're then required to respond accordingly. And under the ADA, there's similarly no clear notice requirement in light of the context or the form of the notice. It can be verbal, it can be in writing. For the FMLA, the regulations provide that where the leave is foreseeable, the employee must provide 30 days advance notice or as soon as possible. Where it's not foreseeable leave, it's as soon as practical. That's been understood to mean 1 or 2 business days after learning of the need for this leave. That being said, if an employee doesn't give you sufficient notice of the leave consistent with your policies, you do need to be careful in just proceeding with denying that request. There may be situations where the leave is not anticipated, such as an employee being rushed to the hospital and needing leave the same day. The statute does state that this as soon as practical requirement, that there's a caveat where there are extraordinary circumstances. So you want to have clearly worded policies and procedures that address the employee's responsibility. You want to enforce that consistently and considering, as I mentioned, any extraordinary circumstances that might qualify for an exception. Now, what are the magic words? Are there magic words that need to be used in requesting FMLA leave? I'm going to address this both in the FMLA and ADA context. As I mentioned, for the FMLA, you don't need to come out and say, as an employee, that I need FMLA leave. You just need to indicate that you are seeking leave and qualify for FMLA leave. So if you receive notice from your employee verbally or in writing that they want time off, and you have some indication that this may be FMLA qualifying, then you should proceed down the FMLA route by requesting the appropriate certification from their healthcare provider, and then evaluate at that point, upon receiving the certification, whether it's FMLA qualifying. Now, under the states that the employers must provide a clear reason for taking the leave, but they don't need to give details about the condition or use trigger words indicating that it's FMLA or ADA qualifying. And certainly employees do not need to provide a diagnosis for the serious health condition as a condition for receiving this leave. But where the leave is requested essentially under the ADA, the employee does not need to provide an express request for a reasonable accommodation or leave under the ADA, but essentially the authority states that the employee needs to request leave and indicate that it's based on some sort of medical condition or reason. And so if it's not clear what the need is, then it's really incumbent upon the employer to follow up to then be able to confirm whether there's being a request made effectively for reasonable accommodation. So next I wanted to discuss intermittent leave. So intermittent leave is leave taken in separate blocks of time based on the same qualifying event. And this has caused employers great consternation because you may have an employee that goes out on leave 1 week at a time, takes off a week, comes back, takes another week off, comes back to work again, and this could create a significant operational impact. Now, another type of leave that could be, or scenario where you're applying FMLA leave involves a reduced schedule, and that's where rather than seeking 1 week on, 1 week off, some sort of intermittent leave, the employee seeks a reduced schedule. So that employee typically would go down from a full-time to part-time schedule, and you would apply the FMLA leave for those hours that are missed. And it's really important for employers to track that FMLA leave that's being taken either in one block of time or intermittently so that you can show that it's being exhausted. And once you get out from under the umbrella of FMLA leave, you have a lot more leeway both in whether to provide more leave or whether to reinstate the employee to his or her position. So, pointers here. The leave must be medically necessary. It must be for a serious health condition, and it must be supported by a medical certification. And the leave should minimize disruption to the employer's business. It is permissible under certain circumstances to transfer an employee to an alternative position with equivalent pay and benefits under the FMLA where it's intermittent leave. So if you have an employee that's on and off every week, and that's going to create a significant operational impact, then you'd consider whether that individual can, for that period of time, remain in that given position. And that's something you'll want to consider carefully in light of all of the restrictions under the FMLA. And also, intermittent leave may be provided in the employer's discretion for the birth, adoption, or foster care placement of a child that's a basis for FMLA leave in addition to the other grounds. If you are in a state that has its equivalent statute for leave related to the birth of a child, you'll want to consider the requirements under that statute as well. And overall, what's really important in this context is to be consistent, that if you have an FMLA leave policy, ADA accommodation practice, you want to be consistent in how you apply your procedures to avoid claims later of discrimination or retaliation based on an individual of a different protected status being treated disparately. And for the FMLA, that's a more concrete practice that you would be applying. For the ADA, when you look at reasonable accommodations, that would really be case by case. But if you have similar situations, to the extent they can be similar, you really want to look at how you've handled this in the past and be as consistent as you can. So, turning to workers' comp, that is, as Kara mentioned, a state framework, and it differs state by state, but there are some common themes. So as a general rule, employees missing work because of a work-related injury or illness receive benefits under the state workers' compensation laws. And every state is different about what a covered employee is. There are some exceptions. The benefit of the workers' comp statute is that if you are sued by the employee, I mean, it's going to be within the framework of the workers' comp statutes with limited monetary exposure, and you wouldn't have the tort liability that you would otherwise have. And then in terms of reinstatement, under the workers' comp laws, there is no requirement for reinstatement, but if an employee is not reinstated to the position in light of the injury, the employee does have certain benefits that he or she would receive. There would be certain payments that would need to be made under the workers' comp policy to the employee to subsidize the wage loss that is sustained. A really interesting consideration is, what if you have an employee that's injured and on workers' comp leave and arrives to the point of being permanent and stationary? And that is a term of art in the workers' comp realm, and it typically stationary refers to the condition not expected to improve. And so you might get to a point where the injury is permanent and stationary, meaning the employee has certain conditions with certain types of restrictions that are not expected to improve. And based on that, the employer in the workers' comp realm would make a decision about whether the employee can return to the former position. But you can also rely on that permanent and stationary finding by the healthcare practitioner. That's typically could be a panel, it could be a practitioner assigned by the workers' comp judge to evaluate the employee. But based on that finding, you could say, well, since it is permanent and stationary and a healthcare practitioner has confirmed this, it's obvious that the employee cannot return to his or her existing position. But this really depends on the state you're in and what the authority is. But many states do find that that is sufficient evidence to find that the employee is not able to return to the former position, that you need to look at other accommodations. Now, another consideration is employees incurring a compensable workers' comp injury may be eligible for leave under the ADA and FMLA, as we've discussed. And so the vexing issue here is you really, when you're faced with these leave considerations, you need to be looking at all three statutes, the workers' comp considerations, ADA, reasonable accommodation, and FMLA leave entitlements, and making sure that you're complying with each one that's independent and gives rise to different remedies.
Andrew, before we move on to the benefits section, I do want to, we've gotten a number of questions on intermittent leave, and I thought it might be a good idea to take a couple of those now, if that's okay. One of the questions is there a minimum amount of time or a minimum amount of days that an employee can take when it's intermittent?
Yeah, there typically is not a minimum number of days. So you could have a situation where an employee takes off a day or two here and a day or two there. I know in California there are some restrictions if it's related to pregnancy, or if it's related to baby bonding following the birth of a child. But you could have the situation where you have very short durations of intermittent leave, and then you're looking there at whether there's operational considerations that would require temporarily reassigning the employee to a different position.
Yeah, I agree. I've seen people ask for intermittent leave in segments of hours, 4 hours at a time, not even a full day. So that's really what you've got to think about for your operational perspective. Another question came in that says, at what point would unpaid leave under the ADA be considered an undue burden for an employer with under 50 employees? And again, this is really a case-by-case basis. Also, it's jurisdiction by jurisdiction. There were just several pretty good cases for employers coming out of the Northern District of Illinois that says, a few weeks to a few months after, FMLA has expired, that would be an undue burden. So the definition for what an undue burden is going to vary based on the size, not only the size of your employer, but also your financial resources. It's a high burden to hit, but it's something that should be constantly evaluated, because maybe it might be okay to have, a years of unpaid leave for one employer. It may be very different for a smaller employer like you with 25, 35 employees, especially if that person is a key employee. So unfortunately, there's not one great answer. It's just going to be very fact intensive and also based on sort of what the jurisdiction in your area considers.
And I would add that when I've advised clients on this issue, which is very distressing to employers, where they have someone that's been out for 6 months, 8 months, and they don't know what to do, I typically take it from the vantage point of, where are you doing business? Is this a litigious environment? Are you in Los Angeles and San Francisco, where there's so many lawsuits being filed? And if you have an employee that's out on a leave of absence and it's unpaid, and they're beyond the FMLA periods, there's no employment benefits that are being provided, maybe you just make the decision that there's no out-of-pocket, and then you just keep the employee on the books for a little bit longer. But, as Kara mentioned, it's really case by case, and you have to look at the authority in your jurisdiction.
And then one more question before, Andrew, I'll let you close with the last section or two for the last 10 minutes. This is a question actually I get quite a bit, so it's interesting it came in. I have a worker, this employer happens to be a public safety worker, who has started to get, quote, brain fog and forgets what they're supposed to do or what steps they should take. This prevents them from performing the core functions of their job. Do we have to make an accommodation? So Andrew touched on this briefly, but first, it sounds like, first of all, this employee has not come to you directly to ask for an accommodation, but that there is some objective evidence that you are observing his or her behavior that could be concerning in the workplace, could put herself in danger, put other people in danger, and not performing the core function. So it starts to get us to be a performance issue. If you have objective evidence that someone's behaviors is impacting their performance, that it may be medically related, at that point I think it's a good idea for HR to reach out to that worker, talk about the ADA process, ask them if they need an accommodation, provide the ADA accommodation paperwork for their doctor to fill out, and start that process. If they don't return the paperwork, if they don't request an accommodation, then you need to treat them just like any other employee and hold them to your legitimate expectations. But if they do have a memory issue that could be medically related, and it does impact a public safety issue of themselves or others, I don't think you want to wait for them to ask for an accommodation. You want to start that process yourself.
Right. The mental disability accommodations are really troubling and for employers, and so there's times when there's no conceivable accommodation that can be provided. And so I always recommend, the most important thing here would be to engage in the interactive process, as Kara mentioned, by reaching out to the employee where you have that information, indicating a potential need for accommodation, and just very thoughtfully document that process. And you could request, go back to your doctor, get a doctor's note, let us know if there's any accommodation that you feel you need. I mean, it's really case by case what words you use and how you approach this. And then you might get nothing back, and then really the employees drop the ball. There's no exposure for the employer, arguably. Or you might get a doctor's note that indicates the person wants to go on a part-time schedule, and then you look at whether that's feasible. Or you could have some sort of restrictions that are just not possible to accommodate, such as making it so that the employee does not have to interact with other workers, which in most positions is just not a feasible option.
All right, so Andrew, why don't you close up with the last few sections, and we are getting a lot of questions on the Q&A. We will stay as long as possible at the end to answer as many as we can, and if we don't get to your question, Andrew and I will follow up with you directly after the webinar to answer your specific question, but we want to at least get through the remainder of the slides in the last few minutes that we've got for the hour.
Okay, so let's move through here on benefits and reinstatement. The ADA does not require that you maintain health benefits during a leave of absence. That's provided as a reasonable accommodation. But if you are providing paid benefits for individuals on leave for other reasons, there is authority that you would have to provide the same benefits to the disabled worker in this context. So you want to be thoughtful in how you apply that. You're not required to reinstate the employee as a bright line test like you would have under the FMLA. You're really looking at the nature of the restrictions, the position that the employee previously had, and operational considerations that would prevent you from holding the position open. But if you conclude that the employee cannot return to his or her prior position because of restrictions that the employee may have or because you had to fill the position, then you need to look at any open positions that employee is qualified to perform. And so that's really a question, again, for the interactive process that you want to document that exchange with the employee and that you've made that overture. And that if you don't assign or offer an alternative position, that there's an explanation for why. Now, under the FMLA, health benefits must be maintained for the full extent of the FMLA leave. It's one of the reasons why it's so important to document it so you can show that that period's exhausted if you want to then discontinue health benefits. And it's a very firm requirement generally to reinstate employees to the same or equivalent position. There are some exceptions. For example, say there's a layoff and you can't, there's no longer a position available, but it's very limited. It's highly litigated, and without extenuating circumstances, we typically recommend holding the position open and reinstating upon the end of the 12 weeks if the employee returns. Now, workers' comp, there's no requirement to maintain benefits or reinstate, but many employers will seek to find employment in the same position or another position for the employees so they can minimize the economic exposure for the workers' comp absence. And again, even if there's workers' comp leave, you're looking at the concurrent FMLA and ADA statutes for what the leave is the employee's entitled to. Now, turning to the nature of workers' comp benefits, I'll kind of breeze through this. Basically, as many of you know, employees can receive a variety of benefits under the workers' comp statutes. There's no consideration of negligence or employer's fault. It's largely a no-fault statute. And the employee can receive medical expense reimbursements, wage replacement, disability benefits, voc rehab benefits, and death benefits. Now let's move to medical inquiry and documentation. This is a really important consideration. Employers get themselves often in trouble by making inquiries into confidential medical conditions in excess of what's permitted under these statutes. And you look at the ADA, the standard is that an employer can make a medical inquiry, but it must be job-related and consistent with business necessity. An example of this would be, if you have an employee that has an obvious medical condition, such as the employee is blind, and you've been aware of that, then to make an inquiry into the nature of that employee's condition could violate the ADA. There's no job-related need there. And then if you are in states like California that have heightened privacy protections, you may be even further restricted, so you certainly need to keep that in mind. And you are under the ADA entitled to request medical certification of the nature, severity, duration, and ability to perform essential job functions. You can request a doctor's note from the employee supporting any request for accommodation. Under the FMLA, there is the FMLA certification form, and you're absolutely entitled to request that form, and then upon receipt of that, make a determination whether the leave is FMLA qualifying. And then the workers' comp laws, that's a much larger discussion, but the states vary on what information can be obtained, and that's usually something that would be coordinated between the workers' comp carrier and the employee, with consultation with the employer about what can be, whether the employee can perform the position and what accommodations need to be provided. Now, one of the last subjects is light duty assignments, and light duty has various different meanings. We'll just want to move one slide over.
Sorry, Andrew, my program just ended. I'm sorry if I just cut everybody out. I'm going to open the meeting controls again one more time.
So light duty is a term of art that can mean various different things. Typically, it's understood to be temporary work that is less strenuous. And many employers, or one way of looking at this is that you can have an employee that cannot perform at any of your existing jobs, but you make a decision that you're just going to create certain duties. So it's not even related to a position. And this occurs quite frequently in the workers' comp context because an employee wants to get the employee back to work to avoid having to make wage payments while an employee is out. So they create various different duties. That can create complications for you. One is that if you provide that light duty only to individuals on workers' comp leave and not for individuals that are with non-occupational injuries or illnesses, you could have potential exposure under the ADA. So under the FMLA, you cannot impose a light duty requirement on the employee who requests a leave of absence. So an employee says, I want to take a leave of absence under the FMLA, and they're qualifying, then you need to provide that leave to the employee. Under the ADA, however, if the employee requests a leave of absence, but you can show that the employee can perform the existing job, you can require that in some circumstances that the employee remain in the existing position as modified. But oftentimes employees will provide a more definitive statement from a healthcare provider saying they actually need to be on a leave of absence, which makes that scenario less likely. Now for workers' comp, as mentioned, the light duty can be offered by the employer and frequently is offered. And employers oftentimes get creative about different light duty assignments they can provide to keep the employee on the job. Now retaliation is the next subject as we get to a close here. Retaliation is a potential claim under the workers' compensation statutes. For example, in California, we have 132A claims that are essentially claims against the employer under the workers' comp statute for terminating or taking other adverse action against an employee in retaliation for the employee filing a workers' compensation claim or threatening to file one. And that's a claim that has certain remedies that are more limited than in a civil action under the ADA or FMLA, but nonetheless pursued quite frequently. And under the ADA and FMLA, you typically see retaliation claims in the context of an employee claiming that he or she was retaliated against for exercising rights to take protected leave. And then for penalties for noncompliance, I'll be brief here. I mean, there are enforcement actions by the EEOC equivalent state agencies as well as lawsuits filed by employees under the ADA and FMLA or state equivalent. And the ADA has very expansive remedies. It can be back pay, compensatory damages, it can be emotional distress damages, punitive damages, recovery of attorney's fees to the prevailing plaintiff. And the states typically have just as expansive remedies for the equivalent disability statutes. And then under the FMLA, you can have back pay, reinstatement, loss of benefits, and recovery of attorney's fees as well. So, in closing remarks here, I have consistently advised clients that of the importance to ensure that the individuals that are interfacing with employees and recording leave, whether it be under the FMLA or as a reasonable accommodation, that they have sufficient expertise in this area. And typically it's someone that has an HR role and has received training on these issues. And there's also a benefit in centralizing this leave process. And that's for a couple reasons. This is such a convoluted process, as you've seen from today, that you really want to have someone that has consistent, ongoing experience in this area to be able to make the necessary decisions in approving leave, ensuring that the interactive process has occurred. It's also helpful to have this be a centralized process if you can. If you have just one or two people within your company that specialize in these issues, it's more likely that you're going to have a consistent application. So you don't have one employee denied leave and then another employee granted leave under very similar circumstances. And if one of those employees was pregnant, you could have a potential, and the other employee wasn't, then you could have a potential pregnancy discrimination claim as an example, and that shows the importance of a consistent application. And then, as Kara mentioned, you want to consider whether the injury is work-related for workers' comp purposes. So you always look at, is it work-related? Have you obtained the completed injury form? Have you submitted that information to your carrier? And then you want to move next to eligibility for FMLA and ADA, and what types of medical documentation you need. Do you need a healthcare certification under the FMLA? Do you need a doctor's note indicating the nature of the restrictions? And then when the FMLA leave is up, then you want to move to the whole ADA reasonable accommodation analysis to determine whether additional leave is warranted. And then for reinstatement, that's the million-dollar question, and that's something you need to tread lightly on, but you very clearly reinstate in most circumstances where the employee was on the 12 weeks of FMLA leave or up to 12 weeks. But when you get to the ADA and reasonable accommodations, you have this multifaceted analysis about whether you should hold the position open and for how long, and then if you can't hold the position open and you fill that position, then what to do when the employee is ready to return to work in terms of finding an alternative position. So that concludes the webinar, and it sounds like we have some additional questions to answer.
Okay, so yeah, I think Andrew and I will stay on as long as anyone would like us to, and we'll just go through the questions that we have not yet answered and go from there. So let me scroll down. Okay, so this is just an interesting one. We've got an employee with approved FMLA leave with 2 different children suffering from different effects of Lyme disease. The paperwork for FMLA was done per child, and assuming tracking is also done separately, we're looking at 24 weeks of leave for this one employee. So importantly, FMLA leave is capped at 12 weeks per 12-month period for an employee. It's not per child, and it's not per qualifying event. So if you've got in this situation, you've got 2 employees or 2 children who have qualifying events, you're still going to be looking at, for that one employee, up to 12 weeks of leave. Again, unless you've got other state or local laws that would provide more generous leave opportunities, the FMLA would only be that. And in terms of if you've got another spouse who's also working at that same employer, yes, that person also has 12 weeks per child or 12 weeks per year, and so that employee could use 12 weeks for maybe the other child. Secondly, what happens, okay, Andrew, what about this? What happens if the employee turns down a job offer that fits his or her permanent restrictions? So it looks like you've got an employee who you want an accommodation, he's got permanent restrictions, the employee has a vacant opportunity or a vacant job for that person, and that person has rejected it. Where do you go from there?
Yeah, so with that scenario, I assume that the employee cannot perform his or her current position, and you're looking at alternative positions. So what I typically advise is you provide a list of all open positions. You could either provide a list of all open positions or ones that you think the employee can perform. And then you make so if you make an offer, you identify one where there's a match, you make the offer, the employee turns it down, then you're at the end of the interactive process. You may want to go one step further and, you could offer a continued leave if you think other positions would open in the future, or you could make the determination at that point that there's no further accommodation that can be provided. And that's really a creative process about how you draft the letter back to the employee or the communication. And one way to do it is just to indicate that you've offered the position, they've declined it, and you've assumed that they do not seek any further accommodation. But it's all case by case in how you address it.
Okay. If a full-time exempt employee is brought down to a part-time reduced schedule, can you take them off their salary and convert them to hourly pay, given that their initial salary was based on a full-time schedule? If you are going to, the answer to that is yes, if it is an ADA accommodation. If you've got someone who is either on an FMLA intermittent leave, in which time they're not being paid really for the time they're out on leave, or you've got an ADA situation where you're bringing someone from full-time to part-time for a short period of time during their recovery of the disability, yes, you can pay them, convert them to hourly based on that original salary so that they're earning essentially a prorated amount of their salary based on their accommodation. Okay, here's one for you, Andrew. What if we are giving instructions to apply for intermittent time off under the FMLA California Family Rights Act through a third-party administrator, and he fails to follow the process and continues to bring us doctor's notes? What is the best way to handle this situation?
Well, if you are using a third-party administrator, they're essentially standing in your shoes, and you have liability for their failure to engage in the interactive process. So it's important, if I'm understanding the question correctly, is that if you have information that's not being responded to, that can be problematic and would be the basis for a claim. I've had litigation where the interactive process, when we're addressing in discovery all the issues where the interactive process was handled by a third party, and that has had the same consequences if it were being handled internally through HR. So I think the takeaway here is you need to make sure that if you're using an outside provider that they're complying with the ADA and being diligent in engaging in the interactive process.
Okay. Is a sprain or strain considered an ADA disability or not because it's a temporary medical condition? And the answer there is, yep, that would be a temporary medical condition. It would not be considered an ADA disability. Question, what if the position does not allow for an employee to take their position to part-time? Are we required to grant intermittent leave per their discretion? Or can we require them to take their leave in full-time block? Andrew, you want to take that one?
Right. So, so, if they're requesting intermittent leave, we'd have to look at how this is playing out. If they're requesting intermittent leave, then we would then apply the FMLA leave statute and provide with typically just grant that intermittent leave. But if you get beyond the 12 weeks and you're into ADA territory, then you'd have some discretion about whether you grant it.
Yeah, I agree. I mean, I think one of the biggest things that employers struggle with is intermittent leave, and how can you manage that, particularly for positions that are required to be in the office full time. And unfortunately, if you are covered by the ADA, intermittent leave only for an employee's serious health condition or their family member's serious health condition is intermittent leave required. You can deny intermittent leave to care for a child or an adoption. That's in your discretion. But otherwise, if it's a serious health condition, Family Medical Leave Act does require you to grant intermittent leave. We have a full-time employee who, under normal circumstances, would have qualified for insurance offer effective August 1st. The employee, since being hired, has had medical issues. He is working limited hours each week and does not expect to be able to return back to full-time hours until September. Are we required to offer him insurance effective August 1st since he's classified as a full-time employee? So this actually delves a little bit into more Affordable Care Act healthcare law. Technically, if you are a applicable large employer, you have more than 50 employees, you are technically still required to offer full-time employees, which is employees who work more than 30 hours a week. You have to make the offer of affordable health coverage. But here it looks like this employee may not be working full-time schedule, and so you would not need to offer him health insurance until he reaches that 30-hour week average. Okay. Can employers automatically initiate FMLA for employees with workers' comp injuries that meet the FMLA threshold? I'll take this one too. Yes, I think that's absolutely right. If you've got someone out who's on an injury and that is, let's say, in the hospital or is under the care of a continuing health care provider for that workers' comp injury, and you qualify for FMLA, you should immediately send the paperwork to the employee to start that clock, because you want to make sure that the paperwork gets returned and you can start the 12-week clock while he is out on workers' comp injury. Okay, I learned of an employee's potential medical condition when I was told he quit because of a medical emergency. I reached out to him to talk about his potential leave of absence under family medical leave and disability, but he has not returned my call. Should my next step be asking my family medical leave disability administrator to mail him the necessary paperwork? Andrew, I'm going to toss that one to you.
Thanks, Kara. So I would, in that situation, if the employee just quits and then you later on learn that the employee had some sort of medical issue, but you didn't know about that during the employment, there's no obligation to accommodate or provide FMLA leave since there's no continuing employment relationship. In this scenario, since you already initiated that process, you could, I wouldn't go ahead and provide a medical certification. What I would do is just one option is in a letter just indicate that you have I think this is a bit challenging because it depends on how you learned about this information. Was it through management or was it from an employee? But typically you can, what I recommend is to have correspondence to an employee saying, okay, if you want a leave of absence, if you're requesting one, provide the documentation. You give a firm deadline. And I oftentimes throw in there that if you don't return it by this date, we'll presume that you have abandoned your employment.
I agree. I think that the employer should document that you tried to reach them, but I don't think you affirmatively need to send out paperwork because, as Andrew commented, the employment relationship is over. The person has, arguably quit, and how you learned out of it and when is an important fact in terms of what your subsequent obligations are. Can you put an employee on leave and count it towards FMLA if you cannot provide modified duty? I'm saying this is like a light duty request under FMLA, and I understand that to be under FMLA. The answer to that is yes. Is that right, Andrew? If you can't provide modified duty and you've got an FMLA triggering event, they should be put on leave if they can't otherwise, or you don't otherwise have intermittent leave available to that individual based on the circumstances. Okay, we're still going. We're getting a lot of these in here. All right. If an employee fills in on their tax withholding form that they're legally blind, should we ask the employee about that and if they need an accommodation if the employee's job requires computer access all day? I'll take that one since I've litigated a similar situation. Even though someone who's legally blind, arguably that might be something that might be obvious or not, you wouldn't necessarily need to have them supply medical certification. I do think it's appropriate to ask them if they need an accommodation, whether that's large print software for their computer or whether it's access to screen access software, commonly known as JAWS. So I think if someone has affirmatively, you're aware on their tax withholding forms that they're legally blind and you know that they use a computer all day, I think it would be appropriate to reach out to them and say, do you need an accommodation? And if so, here's our accommodation paperwork. Would cancer, I think this is the last one. Oh, no, it's not the last one. Hold on, almost the last one. Would cancer and diabetes medical conditions qualify under the ADA? I'm going to say yes to that. Definitely cancer because you're likely under the care of a ongoing medical professional, and I would imagine that the cancer side effects would impact major life activity. And I would think diabetes would as well. The diabetes as an illness would impact a major life activity, and I believe they would both qualify as triggering conditions under the ADA.
Right, and I think even under either it's ADA or California law, one or the other actually codifies and states under the statute that cancer is considered a disability.
Do you need the FMLA paperwork to be returned to initiate the 12-week FMLA for a workers' comp injury, since the employer already has documented certification in the workers' comp medical records? My recommendation there is yes, you should still initiate the FMLA paperwork because even though you've got documentation in your medical records for the workers' comp situation, the FMLA, those are different paperwork. That's paperwork that's certified by the Department of Labor. That triggers different statutory rights. It also triggers a statutory limit where, as Andrew mentioned, there's no real limit on your leaves for workers' comp, but there is under the FMLA. And if you don't send them the paperwork and have that completed by themselves and a medical provider, then it could be argued that they never exhausted their 12 weeks. So you want to have that paperwork returned in order to start getting those 12 weeks triggered. How do you handle a situation when HR finds out that an employee was out for weeks and then has returned to work? I'm not sure I understand that question, but I'm going to assume that that's saying someone's been out for several weeks, they didn't request an accommodation, and they didn't ask for FMLA paperwork, and now has returned to work. What you should do is you should meet with that employee to find out the reason for why they were out and if it is something that would trigger an FMLA. Usually any absences of 3 consecutive days or more gives you enough reason to suspect that FMLA has been triggered, and that would give you the right to then approach them with the FMLA paperwork. And that's what I would recommend doing. And I would also recommend when you inquire with that employee as to the nature of why they were out, if it was related to a work-related injury. And importantly, you don't want to ask details about the medical conditions, but you want to ask enough information to determine, is this a work-related injury, and is this a medical condition that would be triggered by FMLA? And that's when you would give them the paperwork. All right, last question, and kudos to all of you that have stayed on this long. When is it appropriate to request a fitness for duty evaluation? Andrew, you want to take that last one?
Oh, well, that is there's so many nuances to that, particularly under California law. But if it appears, well, under the FMLA and under the CIFRA, which is the California equivalent, there's certain conditions in which you can request a fitness for duty. And so it is, and actually I may need help with this, Kara, because in California it's typically when you have information indicating that the employee may not be able to perform the essential job functions and that you may need a fitness for duty, but usually you have to go through a sort of interactive process before you get to that point.
Yeah, I think under at least the federal outside of California law, what I see is if someone's returning to work from FMLA, you can request a fitness for duty test. If they've been out for several weeks, you can ask them to have a medical certification provided to you that certifies that they are fit to return to full-time or part-time duty before returning to work. You can also, if someone is out on intermittent leave, you can ask for every 30 days, I believe, an update from their medical provider as to the status of their intermittent leave request. So fitness for duty, medical certifications, all of that kind of return to work assessments, all that comes into play, particularly under the FMLA where you do have specific rights. I'm happy to answer a more specific question offline. Given that we are very close to 2:30, I really appreciate everybody's time today. As I said, this is being recorded, and the slides will be made available to all of you. And I hope that this presentation was as beneficial for you as it was for Andrew and I loved getting all of these questions. These were really interesting questions, and it made it much more interactive and fun, so I hope you guys enjoyed that as well. And hopefully log on and join our future webinar presentations. Have a great day.